Okay, welcome to the panel. And I'm going to do a quick introduction, and then my co-panelist will get us right into the discussion. We're going to talk for about 40 minutes or so, maybe a little bit longer, back and forth, with the hope that we can then have time for questions from all of you, because I'm sure you have them, but if you don't, we'll just keep talking. This is a little bit of a tricky panel for Jack and myself. My name's David Barron. I'm now a judge on the First Circuit Court of Appeals here and was a professor at Harvard Law School for about 15 years. And then I was a line attorney in the Office of Legal Counsel from 96 to 99 during the second term of the Clinton administration, then came back to the office as the acting assistant attorney general for the first year and a half of the Obama administration. With me is Jack Goldsmith, who is presently a professor at Harvard Law School, a noted author, both academic work, but also increasingly, you probably read him, he has a recent article in the Atlantic Monthly, which got a lot of attention and writes widely. He was the head of the Office of Legal Counsel, a rare head in that he was actually confirmed by the Senate. And that was for about the same time about 18 months or maybe a little bit less, yeah. So, and there's a story behind that he may tell. In the, was it the second term of the Bush administration? First term of the Bush.
The end of the first term of the Bush administration.
End of the first term of the Bush administration. And so both of us come to this topic with a great deal of affection for the office, but also an awareness of the challenges that it has faced in recent years, and I think probably is likely to increasingly face over time, and the more general problem of how to advise the president. What's a little tricky for Jack and I is, reminds me of a story when I was at a conference in China, and I'd never been to an academic conference in China before. It opened with the presenter introducing the symposium in Chinese, and it went on for a while, and I don't speak Chinese. And there was a great deal of laughter, and then the simultaneous translation came, and the simultaneous the translation in English was, "Nothing important is said in open session." And I think both of us feel we have a little bit of that same problem. Much of what we worked on is classified. What isn't classified is protected, privileged. And I'm a judge. So you put all those things together, there's a bit of a challenge of how much we can say, but we're going to try and be as candid and open as we can be. Okay, I think the best way to start is Jack is going to give us, I think, just some background about the general problem that the office confronts in trying to provide legal advice to the president.
Right. So I'm actually going to walk around. Can you hear me if I don't? Do I need to speak into the mic?
A lot of us are deaf.
Do we have, yeah. Let's see if it works. Testing.
Is there a second one there?
I can get back to it.
Okay.
Yeah. Is that okay? Can you hear me? Yeah. Okay. So thanks for coming. So first year of law school, and for most of law school, when you learn about legal interpretation, you're learning about legal interpretation primarily, it's actually less true than it was 20 years ago, less true now, primarily through the lens of judicial interpretation. And we study judicial opinions, and we teach the students judicial opinions. But there's a whole other world of interpretation, and it's called executive branch interpretation. And it takes place kind of in relation to, the executive branch lawyers look to judicial precedents, but it takes place really on a separate track with separate traditions, separate interpretive principles, separate constraints, and a lot of times it has no connection at all to what judges do. So what I want to do is just describe the structure of the issue that we're talking about, which is legal advice to the president. I'm going to explain what the Office of Legal Counsel, where David and I worked, does. I'm going to explain some of the challenges to interpreting law when you're advising the president, especially in a national security context when the imperative to get something done is very strong and the stakes are high. And then I'm going to let David fill in and tell me what I got wrong, and then we'll go from there. So as you know, Article 2 of the Constitution says gives the president a duty to take care to faithfully execute the law. So within the executive branch, the chief executive officer is the president. The executive power is vested in the president, and he has a duty to take care to faithfully execute the law. And most of the time when we think about faithfully executing the law, we think about two things. One, that means he has to comply with the law. And two, that means he enforces the law, execution. But if you think about it for a second, before you can apply the law and before you can execute the law, you have to know what the law says. And that takes an active interpretation. And there is a lot of law governing the executive branch. And so there's a lot of executive branch interpretation going on every day about what the law is, so that ultimately the president and all the other executive officials can ensure that they faithfully execute, faithfully comply with the law. And to ensure that when the president or other officials want to take action, that it complies with the law. So the president has this duty. The president doesn't have to be an attorney. The current president isn't. The last president was. But the president is a busy person. So since the beginning of the nation, by statute and custom, this power of legal interpretation by the president, which is the ultimate power in the executive branch, has been delegated to the Attorney General in the Department of Justice. And for years, going back to the founding, there was something called Attorney General opinions. When there was a question about a legal question within the executive branch, the Attorney General would write an opinion and issue the opinion just the way courts do. And that's basically the way it worked. David will talk a little bit more about the history, so let me just go to the structure. Since the 1950s, at least, the Attorney General's function of interpreting the law, which is the president's power to interpret, has been delegated to the Office of Legal Counsel, where we worked. And this is an office inside the Justice Department. It's an office of about 22 or 23 lawyers. And they basically exercise the president's power delegated to the Attorney General, to OLC, to interpret law for the executive branch. Now, that's very misleading because the executive branch is huge, and there are a lot of lawyers in it. So there are all these agencies, like the Department of Defense, Department of State, the CIA, just to mention some national security ones, the NSA, and we can go on. There are all these agencies in the executive branch, and they all have general counsels. They all have chief lawyers that are essentially doing the same thing within their agencies, and then there are lawyers all the way down. So there are lawyers throughout the executive branch in this more or less, and we'll talk about the or less later, hierarchical system. And so what is OLC's role here? Well, OLC does several things. One, if there's an interagency dispute between the Department of Homeland Security and the Department of State on some matter, that's the kind of thing that can be resolved by the Office of Legal Counsel. One of the things they do is to resolve interagency. One of the things they do is to resolve interagency disputes. It's kind of an adjudicatory system within the executive branch. Another thing the Office of Legal Counsel does is to review bills of Congress to ensure that they comply with the Constitution, and to advise the President and the White House about the extent to which they comply with the Constitution. They vet executive orders and the like. But what we're talking about today is when OLC gives advice to the President on some legal matter. And it can be either directly to the President or to the White House counsel. So the President, we're going to talk about this, the President has his own lawyer in the White House called the White House counsel. And the relationship between the White House counsel and the Justice Department is there's often a tension there. But what we're talking about today is advice to the President or advice to a senior executive branch official on some matter that's very important to the President. Okay, so that's the structure. What about the interpretive posture of the Office of Legal Counsel? So when I testified, I was probably I was the lucky one who was the last person to be confirmed for the Office of Legal Counsel who had an easy confirmation hearing. And that's because the office didn't really become controversial until after I got there. That wasn't just because of what I did, but that's the way it worked. And I testified. I had one question at my hearing. Nobody showed up. It was great. But in my opening statement, I said something, this is almost verbatim, that I viewed my job as the head of the Office of Legal Counsel to provide the president and other executive branch officials with objective legal advice free from any political considerations. Objective legal advice free from any political considerations. And I testified to that, I swore to that, and I believed it. And that belief lasted about 1 day on the job. Not because I didn't try my best to give good legal advice, and not because I tried to discount political considerations, but I learned quickly, and again, David and I might have some small, maybe some large disagreements on some of this stuff. I learned quickly that it was more complicated than that. For one thing, it was no accident that George W. Bush chose me to be the Assistant Attorney General for the Office of Legal Counsel rather than David. And it's no accident that Barack Obama...
What are you getting at there?
No. That Barack Obama says, David, we have different... William Rehnquist, former Chief Justice, who was the head of OLC, he said the president chooses the Attorney General and the head of the Office of Legal Counsel in part based on their, what Rehnquist called, philosophical attunements, by which he means the kind of interpretive posture, the fundamental commitments you have about sources of law, about various powers of the presidency and the like. So it wasn't an accident that he chose me, because I had certain views on things. Not that, and I in the office, I tried to discount and indeed I tried to just erase anything I thought before I got to these questions, but I'm sure it affected my judgment. Second thing is, as Elliot Richardson, who was an Attorney General, the one who famously resigned in the Saturday Night Massacre, said, he says that the Attorney General, when advising the president, has to have the political dimension in mind. And he didn't mean that you have to play politics, but what he meant is that the Attorney General and the Office of Legal Counsel, when they're advising the president on a legal question, like, can you use force abroad in this situation, for example, that you're not like a judge. You're not truly neutral. You're embedded inside of an executive branch, and you're not neutral about the president's ends. You want to try to help the president achieve his ends. That doesn't mean, so that's why I think that's one of the many reasons I think it's misleading to think of OLC as like doing what judges do. Another reason it's misleading to see what OLC does as doing what judges do is that OLC has different sources of law than judges. There are executive branch precedents and legal opinions going back to the beginning of the country in multi-volume sets, available publicly, many of them, that constitute executive branch precedent and that we rely on and we treat as binding precedent within the executive branch. Now, if there's a judicial decision that goes in another way, most OLCs, it was my view that trumps OLC and that we're bound by what the Supreme Court says. But the truth is, on important national security questions especially, there's often no controlling judicial precedent. So another reason that OLC in advising the president is different than a judge is that you have different sources of law, you have different constraints, you're not indifferent. When I say not indifferent to the president's ends, I don't mean by that, and this is very important, that it was my job to find a way for any legal argument that was possible for the president to do what he wanted to do. I definitely don't mean that. But I did mean this, that I didn't think it was my job just to say yes or no. If I thought that something that was proposed wasn't lawful or was seriously problematic legally, I tried to work with the White House counsel or whoever the client was, the actual client, to try to find a way to achieve the president's goals in a way that was lawful. And that's not what a judge would do overtly. So that posture was a little strange. Why don't you want to fill in for that? Yeah.
Okay. One thing, just you have to take the fact that Jack and I are doing this class rather than Greg. Oh, well, let me take the mic from you. Wait, is this working?
I'll be figuring that out while you do this.
Can you hear me? No. How about now? Can you hear me now? Okay, good. Okay, just take with a grain of salt that this is a session being put on by two people who used to be in the Office of Legal Counsel rather than the White House Counsel. So it's no accident that Jack forgot to mention the White House Counsel until pretty far along. And the former head of the office who first hired me, a man named Walter Dellinger, who was, many of you may know, is a terrific person, was a great head of the office, likes to tell a story about his time when he was the head of the Office of Legal Counsel. He had come out of the White House Counsel. He was a deputy in the White House Counsel at the time. And he had a conversation with the White House Counsel when he got to OLC. And the conversation was about what is the proper organizational chart for giving legal advice in the executive branch. And Walter said to the White House Counsel at the time, see, you think that the chart goes president, not over here, right here is White House Counsel. And then OLC is not here, and the AG is not here. There's just all these different little tiny agencies that report up. And way over here is one of them called the Office of Legal Counsel. And Walter said, see, my idea is the organizational chart goes like this. There's the president, there's the AG, there's OLC, and then there are all these lawyers reporting to OLC, and way down here is White House Counsel. So, two different ways of thinking about it. And but that dynamic is a really important one to keep in mind. That's a tension that all executive branches face as to where is the real legal advice coming from ultimately, because in the end, Jack, I don't know how many times you even spoke to the president in the course of your tenure. I can count maybe 2 or 3 times.
About that many.
Somebody ultimately is talking to this person. It's not either me or Jack or the head of the office. That's the last person that talks to him. It might be the Attorney General. Often it is the White House Counsel. There's a chief of staff who's not even a lawyer. So there's just a reality to how the final thing is communicated and what's done with it that it's just a fact. Second thing.
Can I just to ask you a question? So, and what David is emphasizing is it's ultimately the president who has the ultimate authority to decide. So the president can overrule anyone below him that he wants on any of these questions formally. And so what you're talking about is when some legal decisions have presumptively been made, and if it's the kind of decision that the president is interested in and it's taken to him, there's going to be somebody who takes it to him for a decision.
Exactly. And then there are 2 other things to keep in mind. One is the unusual thing about the kind of legal decision-making we're talking about is it's occurring before any action has been taken. So the government does lots of things, and after it's done something, our office, the Office of Legal Counsel, is usually not in the picture. That's the Solicitor General's office. That's the lawyers who then go into court and litigate it, because there's already been some action taken. Now somebody's suing or challenging. And there's all these lawyers that then are in a position to take legal positions for the government that are defending the government's action or confessing error, as they sometimes do. We're in the business, in the Office of Legal Counsel, when I was there and when Jack was there, before any action has been taken, the question's put, can something be done? But that's a very unusual position. That's not a position, except in very rare circumstances, that judges ever confront. It's a dispute that's already arisen because of some action that's been taken. But we're in a position when you're in the office of a thought has occurred to someone about something to do, sometimes a very crazy thought. And they've come to ask, can I do this thing? The consequence of that being the posture is, yes, no isn't the only thing you would do. Those of you who counsel in whatever setting you're in, you're advising a person who's got a problem or an idea or a plan of action. And you're trying to assist them and think, is this a good plan of action? A problematic one? Is there some other way I could achieve that plan of action? And right in the title of it, of the office, I think you get a sense of this. You'll notice called the Office of Legal Counsel. In an earlier iteration of it, when it was delegated from the Attorney General, for a time, this function was delegated to the Solicitor General's office. I think the idea there was, Well, that's a relatively neutral, disinterested set of people, and they're connected to the courts, and they're kind of the 10th justice, that idea, so that would be a good place for it. But the problem is the Solicitor General's office is in the business of defending actions that have already been taken. The habit of mind in that office is to advocate and defend a position, not necessarily to be advising in advance of action. So it then slowly shifted. And the first name given to this function when it was delegated into the what became the Office of Legal Counsel was, I think, called the Executive Office of Adjudications. But see, they were thinking of it like a judge. But then that's not what they're doing. They're not really adjudicating. And the name then finally changed to Office of Legal Counsel, which I think is a very accurate name for what the office ultimately does. It's counseling. Now, a thing that's problematic, and I think a source of a controversy that's befallen the office in recent years, is the way that counseling takes place, just like you do in your own professional lives, can have all kinds of forms, some of which look nothing like what a judge does. It's having coffee with someone, right? Raising an eyebrow, folding your arms, not calling back. Right? All kinds of different ways that you can communicate your thought about something. That's nothing like what a judge does. But the office also writes these things called OLC opinions that look very much like what judges do. As a lawyer, you probably do that for clients sometimes, right? You write an opinion letter or a document that has all the shape and form of an opinion to advise, particularly in the tax area, this may be the case. Well, the more the office looks like it's doing what judges do, the more there's this concern, who are these people? Because if they're really acting like judges, they don't seem to have any of the attributes that we would assign and that we do assign under the Constitution to judges. They don't have life tenure. They have none of the independence. They're sitting right there with the president. They're picked by him for a short period of time. They're way too political to be performing that function. And that's true. But they're not at root. The office isn't designed, at least as I see it, to be performing that function. It's a counseling function. It's an advising function. At the same time, the only reason the office exists is because that counseling and advising function, it's thought, has to be performed by a set of people who are not just political. If you just wanted political legal advice, you would not create the office. There'd be no need for it. You've got plenty of people who could do that. So the very existence of it reflected a fact that presidents wanted, and the government as a whole wanted, some sense that there would be something like objective, neutral legal counseling going on. Right? Somebody would be thinking a step back. Not just, you'd like to do that, how can I help you? What's an argument to make that would enable you to do it? But somebody would actually counsel the executive branch about its legal obligations and whether what it was doing was legally a sensible thing to be doing. So that's at the root, I think, of what the office does.
Can I just amplify that in a couple of ways? The other challenges, David just mentioned some, and I mentioned some. When the Office of Legal Counsel is providing this counsel advice, sometimes writing legal opinion, on very important questions, especially on ones of national security, can you do this? Can we do that in national security context? Think about how different it is from the judges. Think about from a judge and how different the dynamic might be. You've got someone telling you, this is really important to our national security, it's really important to the war effort, a lot of lives are at stake. That's how it's teed up sometimes. You're presented with a question, and you're presented with facts, and you're sometimes not sure how sound the facts are. You don't really have a robust fact-finding function. There's no formal briefing. The office has a policy of asking the agencies that are seeking advice to provide their views in writing so that we have the experts' views in writing before the office would opine on it. If the advice is going to the White House especially, they tend not to do that. There's no dissenting opinion. It's very difficult. All of the reasons why we think adversariness is a good thing in the judicial process, to flesh out weaknesses and arguments and the like. it's hard to replicate inside the executive branch. We try to do so, and the office has policies about getting input from anyone who's expert and interested on certain matters, but that is very challenging. What was the other thing I was going to say? Oh, just to go a little bit further than David did on the counsel function, sometimes it's very important to have a Justice Department legal opinion and a Justice Department legal opinion. If the government, especially if there's government action at stake, I'm not sure if you'll agree with this, especially if there's government action that is contemplated, they say, can we do this covertly? Can we engage in this covert action? And the covert action statute says that the president has to make a finding that the covert action, which is basically an action designed to influence foreign policy, it's not intended to be acknowledged. And the president has to make a finding that the covert action is lawful. So what if the covert action implicates a criminal statute, in the sense that you're going up near a criminal statute, you don't think you're violating it, but the client wants to know, is it lawful to do this in the face of this criminal statute? Well, I can tell you that the people who are engaging in the activity on the ground and their superiors in that agency, they want an opinion from the Justice Department. They want an opinion from the Justice Department saying, yes, you can engage in this activity with these strictures on these assumptions, and if you do this, we believe that it won't violate this criminal statute. There's no escaping that problem. If there's a criminal statute that Congress has passed, and the president wants to do something not to violate it, but related to it, someone has to interpret that criminal statute and give a ruling on it and say whether the contemplated action crosses the line or not. And the reason the Justice Department opinion is especially important there is it gives comfort to the people who are engaging in the action that they're not going to be engaging in criminal action, and that gets people's attention in the government. And there's a pretty good chance that if they follow that advice and stay within it, and then it turns out the advice was wrong or something like that, there's a pretty good chance that they're going to be okay. And they want that. And there's also there's a very good chance that if the Office of Legal Counsel or someone in the Justice Department says, no, you can't do this because it would violate a criminal statute, that action isn't going to happen. People don't take those types of risks in my experience. Is that basically your experience?
Yeah, no, 100%. I mean, I think the point, I think, of both these comments, if you pair them, is that the way the issue tees up is just not immediately out of the blue. We'd like to do X thing. We wait your opinion.
Yeah.
It just doesn't work that way.
Sometimes it's portrayed that way.
Yeah, and that's just not how it is. You know, it's a much more iterative process, which often needs to result in an opinion. But that's after the issue's been discussed, at least in my view, if the process is working well. Because for one thing, the lawyer needs to understand the problem. I mean, just to give you a sense, I taught local government law, I love teaching local government law. My very first meeting in the Office of Legal Counsel, all I could see was generals around the table. You know, they weren't mayors of cities, so I was thinking, you know, Dillon's rule didn't seem very relevant to that conversation. And I think that's a basic problem. The people that are often chosen for these jobs don't, you were unusual, Jack, because Jack had taught foreign relations law and had a real experience in national security law. I really had very, very little when I came in. That's often the case because the range of problems that you're dealing with in that office, you're reviewing for constitutionality every piece of legislation that is proposed. So every bill that hits the floor comes through the office, and we have to do a vet of, is there a constitutional problem? Everything from a tiny little bill to create the bicentennial, or the commission to celebrate the first century since Ronald Reagan was born, all the way up to the Affordable Care Act. So the range of and when I was there at the very beginning, there were all the issues about the purchase of the car companies coming out of the bailout. I mean, the range of legal issues you're dealing with is massive. And then on top of that, and this is a particular challenge, I think, that the office is experiencing as the whole country is in all its various ways, we have been engaged in armed conflict systematically for now going on 16 years.
And I'm doing a panel on that in about an hour and a half.
Yeah. and no indication that's likely to come to an end anytime soon. But that's a relatively unusual experience. I mean, I don't even know if there's any precedent for that kind of sustained armed conflict that the United States has been engaged in with no foreseeable end to it. That generates lots of legal questions. And that means the office becomes front and center as an engaged participant in that activity, not episodically, not as one-off actions, but through this entire conflict with all its dimensions and range, becomes a major actor in shaping the architecture of it. And that puts an enormous amount of spotlight and attention on the office. Just a story that, for me, highlighted it. Soon after I got to the office, someone who was in the administration at the time, who we've become somewhat friendly with, invited us to a concert. It was a Green Day concert. Everybody know Green Day? That's the younger people in the audience who are laughing. So it's you don't go to Green Day. OK, good. I'd never been to a Green Day concert. I don't think I'll go again to a Green Day concert. But the lead singer of Green Day, I think, is Billy Joe. Is that right? OK, so this person had backstage passes. We get to meet Billy Joe. Person who was with me was a young lawyer in the administration. And we're there with Billy Joe. I didn't have much to say to Billy Joe. He didn't have much to say to me. But she says to me, tell him what you do. I was like, Billy Joe is not interested that I'm the acting assistant attorney general for the Office of Legal Counsel. And she said, no, he's really interested in the Office of Legal Counsel. And I thought to myself, we have a major problem. Yes. Because when I was in the Office of Legal Counsel in the second term of the Clinton administration, my parents didn't quite understand what the Office of Legal Counsel was. They kept thinking maybe it was the White House counsel. That they had heard of. But in the last 15, 20 years, you can have a room full of people interested in hearing about the Office of Legal Counsel. And that's a consequence of the nature of the issues that have been coming to the office and the central role it has to play in resolving them, which has many, many virtues. But it has changed, I think, the visibility, for good and for bad, of that office and the function it performs.
So let me just back up and give the backstory to that. What really brought the office notoriety, and this is not news, the office was known by major legal players and political players in Washington going back to the 70s because it did have this very consequential role inside the executive branch. But it wasn't generally known outside the executive branch, and certainly not in the public. And in the early years of the Bush administration, the first term of the Bush administration, right after the 9/11, for the first couple of years, the office issued some opinions, which later leaked, that were, in my judgment, flawed legal opinions, and in the judgment of very many people, flawed legal opinions. And these concern interrogation and surveillance and lots of controversial issues that you know about. And people looked at these opinions, and some of these opinions didn't seem persuasive at all. Some of them seemed like they were written more like briefs than they were like even a pretending to be a detached legal analysis. And they approved some very controversial things, some very aggressive interrogation techniques, for example. And which raised the question that David raised, who are these people, and why should we allow the people in this office to be deciding that the president is allowed to do all this stuff? Now, of course, the president himself could have made the decision, or the attorney general. The president could have asked a lawyer working for a firm in Washington for a legal opinion and decided on that basis. So ultimately, this is the president's power that's being exercised. But this office was generated in the years after 9/11 some opinions which, when they came out, they weren't convincing to anyone, and they seemed to be approving actions that were, to many people, unlawful and separate issue, immoral. We can talk about whether that's even relevant.
Jack, just two things that I think just to, you probably know this, but I think just maybe it's helpful to hear from the perspective of people who are in the office, these features of what has made the advice-giving function on law to the president such a charged issue in the last 2 decades. And, historically, it's been charged at other times. In World War II, Robert Jackson later on the Supreme Court, who the justices were speaking about last night, wrote a very famous opinion, infamous in the eyes of many, concerning the destroyers for bases deal, which was when Churchill was begging desperately for the United States to give him these aging destroyers so he would be able to fend off the Nazi attack on England. And there were neutrality statutes, which made it a federal crime to provide assistance to a belligerent in a war that we hadn't entered. And ultimately, Jackson approved the destroyers for bases deal in a legal opinion, which was a source of tremendous controversy when it came out. So it's not completely unique. What is, I think, unique is the sustained nature of the conflict that the country's in and that the advice has to be given, as I mentioned, but also the way this conflict is played out with so much of it done covertly. When these opinions come out, it's often the way in which the activity is discovered. It's through the lens of the legal opinion. And that really charges up the issue because the actual action wasn't even known by the public. And then when they actually hear about the activity itself, the interrogation practice, the detention practice, the first thing they see is the legal opinion describing it and putting its imprimatur on the legality of it. And the whole thing looks so suspicious just in the way that I think it presents itself. And understandably so, but that's a function of much of this activity being done in secret, which then generates just something very intuitively concerning to people, which is this notion that you hear all the time, secret law. Right? And that just seems so opposite of what a democracy would have, something called secret law. But if you think about it, most advice giving is done in secret. It's privileged. How could it be otherwise? Before somebody acts, they don't go out and announce, I'm thinking of doing this really aggressive interrogation practice, and I'll be asking whether I can do it. That just doesn't make any sense.
But
right?
in those cases, the activity is secret and the legal opinion is secret. It's different when the action is public, but the opinion is not disclosed.
Correct. And it's that combination really, and then there's a third thing, which is much of what we're talking about are legal questions that won't get to court. And everybody knows it won't get to court. So as much as you can describe this as legal advice giving, usually you're advising on something, but then an action will be taken, and then there'd be a dispute, and you'll have your day in court to resolve it. But for most of these charged issues, there's an understanding that it's very unlikely this will ever get to court. Partly because courts won't touch the issue through all the various doctrines they've developed. It's a political question. It's not justiciable. No one has standing. It's not ripe. There are thousands of ways that it won't be. Or it's never known that it happened, right, if it's done secretly. So in effect, you've got somebody who's just advising, but they're advising on an incredibly charged issue, which, if known to the public, would be shocking or source of great controversy. And they're effectively the last word on that issue. That's it. That's the only legal vetting it really may ever get. So that's an enormous amount of pressure on that decision.
And then so people are naturally and appropriately suspicious that this office of unknown lawyers inside the Justice Department would bring any kind of real legal constraint, would have any on the president. For all the reasons discussed, decisions in secret, no really robust adversary process, no dissents, national security context where the stakes are high. And then these opinions come out, and they're really the first national security opinions that I think had ever leaked from the Office of Legal Counsel. And it basically confirmed the worst suspicions that, there really isn't legal constraint on the executive from inside. And we can talk about that in the question and answer. So there have been proposals I'm going to talk about. There have been proposals, how do we fix this problem? And it turns out, if you think that's a problem, it turns out to be a very hard problem to fix. So Bruce Ackerman, a professor at Yale, proposed something like an independent body outside the Justice Department, a council of some sort, council I think he called it, of some sort.
Tribunal, I think.
Tribunal,
Tribunal,
yeah. So to make it sound like a judicial, and this would be, they would have independence and they would give legal advice. And who are these people? These are people who are somehow independently chosen. The process can be various, but they would go through some independent vetting process. And the point is they wouldn't report to the president. They would be independent of the executive branch. And by the way, something like this, very much like this, was proposed right after Watergate as well, when it was thought that the Justice Department, at least for a while, had become corrupted and wasn't giving proper legal advice. And something like this was proposed after Watergate as well, and it was rejected then. And the idea, basically, without getting too much into the details, is you have an independent court inside the executive branch, so you can get more court-like legal advice for the president before he acts, so you won't have an opinion like we saw coming out of the Office of Legal Counsel about interrogation in the early 2000s. That sounds good, I think, at first cut. I think it doesn't sound so good at second or third cut. For one thing, it's almost certainly not constitutional. And I'm sure that's what the Office of Legal Counsel would say. And not just because it takes them out of business. Because the Constitution gives the president the power to take care to faithfully execute the law. That's not something I think that Congress can take away from the president and give to an independent body. But secondly, and this is a subtle point, and a lot of people aren't convinced by it, there are two other issues, at least David may have some more. One is this independent tribunal, the president is ultimately responsible for the actions that he takes. And he's politically accountable to the country for the actions he takes, for good and for bad. And there is an idea that if you had a tribunal that was independent, that was, for whatever reason, saying no to the president on close cases, and a lot of these issues, I can't emphasize. Some of those opinions in the early 2000s were really bad opinions, but most of these issues are really hard and really close, and frankly, there's no obvious answer. There are no judicial precedents. The statutes often have never been interpreted even by the executive branch in a robust way. There's just a lot of room, frankly, a lot of gray area in the interpretive fold. And if the tribunals are saying no to the president, and the president is somehow bound by that, and therefore is not able to take steps to do something to keep the country safe, that taking that responsibility away from him is a dangerous possibility, independent of the constitutionality. On the other hand, these folks might end up being yes people. It could be, everyone thinks that if you give an independence to a body, that they will stand up to the president. The opposite could happen. They could become co-opted by the president and just become less constrained, and their independence would give them a different kind of authority to let the president do what he wants to do. So this has been proposed as a problem for the undoubtedly difficult posture that OLC sits in. For constitutional and practical reasons, I don't think it works. I'm still of the view, despite all the problems that the Office of Legal Counsel has had, that this arrangement, the President, Attorney General, OLC, as in this counselor role, but also presumptive decider of important legal issues in certain areas, is the least bad arrangement for executive branch lawyering at the very highest levels. And by the way, these issues, just to emphasize, they replicate themselves all the way down. The General Counsel of the Department of Defense has a million difficult legal issues that he answers. And the same issues come up about no judicial precedent, hard legal question, some discretion about how to act. Really, it's a judgment call or where to draw the line. This replicates itself throughout the executive branch. In my opinion, the Office of Legal Counsel, which is an office that is relatively independent and does have a tradition that has not always been upheld, but a tradition of relative detachment and relative professionalism on these questions. I think, and there are various ways to do this, there are various ways to have consultation with the White House, but I think it's the least bad option, which is not to say it's a great option. I think it's the least bad option for deciding these hard questions of executive branch lawyering.
I agree. Maybe even a little sunnier.
Okay.
It's a pretty good option. And I, when Jack was talking about this tribunal, if you go back and you read the history of the New Deal lawyering and the Attorney General at the time, Homer Cummings, there was a kind of tribunal that the executive branch was going to for answers. It was called the Supreme Court of the United States. And Homer Cummings didn't much like the answers he was getting from that tribunal. And it created a real deep tension. And, you know, at least many people don't look back on those days as a high watermark of the Supreme Court's adjudication. So some of this is just also embedded with not just a procedural question in the way Jack and I are talking about it. How do you give advice? Who gives it? What's the structure? It's deeply connected to people's views of the substance of the decisions. And our legal culture and society as a whole is very divided on some of these legal questions. People's views of the scope of the legal powers of the president as a general matter is not something about which there's a consensus. The particular question of what the scope of the president's legal powers in war and the exercise of military force is also not something about which there's anything approaching a consensus. So it's not surprising that when you then get those questions teed up to be decided in this way, and when people see the outcomes, people are going to have very strong and differing views on it. I think coming back to the idea of why I think it's a pretty good option is if you think about some really formalized group of people outside of this, they have to be asked a question. The president has to go to them and ask. And lots of stuff gets decided in the executive branch that never comes to the Office of Legal Counsel. Only 20 people. How much could they do? So there's all kinds of legal decision-making that's going on all the time without them. And there's no real clear formal process as to what is a question that must go to the office and what is not. A lot of it's prudential, a lot of it's norms, practice, precedent, history, custom, that leads a question to be thought it needs to go to the office. And there is a concern that if you set up something so disconnected and removed from the daily back and forth of legal decision-making, that they just wouldn't ask them a lot of times. That doesn't seem to me better if that was the situation. And there are at least reports and concern that, you know, there's questions that are already going to OLC is dropping off, which I don't think is a good thing. So there's just a practical question of would they even get the question. The other piece of it, though, is if you go on to the other side, and there's been some writing lately that, well, let's just be real about it. Let's just forget this person mattering. There's ultimately a White House counsel, and he checks with lawyers because he doesn't want to get in political trouble by taking a legal position that's just absurd. But he'll hear the various options, and then if he hears one that seems, you know, by a seemingly respected lawyer in the administration who's got a favorable view of what the president could do, White House counsel will say, well, I'll take that one. And why should I listen to the one that's not favorable? That's a different model. And you can understand how it's got a certain plausibility. But I don't think that that's a very attractive option because the immediate pressures on this particular lawyer are so direct that their ability to have distance and to see around the corners and what some of the actual stakes of the legal controversy that they could generate are, I just think it's just not as developed. They're not as well situated to see that as somebody who's got a slight remove or more remove, like the person in the Office of Legal Counsel does. And in fact, from the perspective of the agency general counsels, some former agency general counsels are probably in the room, you know, they like OLC to some extent. Because when they get one of these really hard questions that Jack was talking about, maybe we'll ask OLC.
Let them have the problem.
Yeah. And OLC would sometimes like to do that, but it's got nobody to ask.
Yeah, I would say once a week, at least, when I was there, I would get a question. And I would say to myself, please, please don't ask me that question. Don't make me answer that question because there's just no way it could end well for you. You know, no matter what you say or do, it's just a really difficult, you know, the United States wants to do something, the legal issues are hard, it's going to be controversial no matter what happens. But OLC can't. There's nowhere to pass that question.
Could you address the division of labor between OLC, which being ancient, when I was in the White House and in the department, OLC was the place you went to, and we relied on OLC lawyers in the White House, and the White House counsel was almost small to non-existent. Now
Right.
it's exploded, and OLC seems to be pretty disregarded. About the trend of that and whether that's...
You want to take that? You want me to?
I'll start. Yeah, my own experience, and I was only there for the first year and a half of the administration that I was in. This idea that they've been disregarded just doesn't strike me as remotely accurate. Now, of course, I only see what I saw, and I suppose there could have been things going on I didn't know about, that I wasn't being asked about. But my experience of it was that the office was quite integral to the legal decision-making that was going in. There was a very large White House counsel office. Some of that is a function of things that aren't really directly about the kinds of questions that OLC decides. Some of that has to do with congressional investigations and the way that congressional investigations have become such a dominant part of how policy gets made now, or what happens in Washington, and the need for people to be able to handle that. Some of it also is a function of the ethics questions that arise now, which are a source of potential great political peril, and which need to be lawyered, and which largely are not done by the Office of Legal Counsel. A lot of that ethics advising on nominations and the legal questions that nominees have, that comes through the White House counsel. And then a lot of the political questions around fundraising, campaign finance, travel, all those type of issues also are a source of potential real peril.
What about drone strikes?
Yeah.
Drone strikes.
So drone strikes, well,
Answer that?
go ahead, Jack.
What's the question precisely?
Well, the question precisely is, I understand that a large function in the Obama White House.
Can you give him a mic? We can't hear.
Yeah, we'll
sorry.
repeat the question. We'll repeat the question for you.
Okay. I understand that in the Obama White House, a large section of the questions presented to it were about whether we should do drone strikes or not. And that would impress me as possibly an OLC type question.
And it was a question. Well, OLC didn't decide whether we should do drone strikes.
No.
But OLC definitely was involved in answering that legal question about whether it was lawful to do uses of force in certain contexts. Can I go back? I'll come back to drone strikes. Can I just give a different kind of answer to your question about the relative power? And then I'll come back to drone strikes between OLC and the White House counsel. So there are many. The office has these offices have a history. And over the last 50 years, there have been many different models of how these things actually work. And frankly, a lot of it depends on personalities. If you have a really strong OLC, someone with a lot of credibility, or a really strong AG who has a very powerful relationship with the president, or a weak AG with a very powerful White House counsel, personalities matter a lot. The president's preferences matter a lot as to how he wants to structure his legal advice. So there was definitely, at least as Charlie Savage reported in his book Power Wars, there was definitely a move in the Obama administration. I wouldn't say to push it to the White House counsel, but to have more deliberation among the agencies openly, among the lawyers. And this is a process that has always occurred in the covert action context, the lawyers group. And I think that process expanded under the Obama administration. So I do think, my sense was that OLC was at the table and on many issues having the final say, but they were involved in the interagency discussions. And frankly, when I was at OLC in the second half of the first term of the Bush administration, even then when they had this weirdly OLC-centered view of how the executive branch should run, at least when OLC was telling them yes all the time, OLC, the White House counsel would still have, on any important question, would convene a meeting, and you get all of the relevant agency lawyers, the Defense Department, the CIA, the State Department, if there was something that needed to be done that implicated those agencies' equities. And there would be a discussion, and we would discuss the law, and we would inform one another. OLC still had a dominant role, and I think OLC still had a dominant role in at least certain parts of the Obama administration. So and these relationships really, it really just depends on who these people are, and you can organize this in many different ways. Ultimately, the Attorney General exercises the President's power to interpret the law and as Chief Executive, and that's delegated to OLC as a technical matter. I mean, it's also by custom, and it's challenged a little bit at the margins. But there can be a White House process. The White House counsel, independent of those substantive responsibilities that he has that OLC doesn't, like ethics and judges and the like, also has this very powerful power to convene a meeting. This is an important issue for the President. Let's get the lawyers together and talk about it. That's a very important power. So on drone strikes, my sense from the Obama administration was that they had a very robust process for, they did have a very robust process for high-value strikes that involved lawyers and intelligence officials and cabinet officials and the like, and it was very highly proceduralized. But behind that were some OLC opinions that authorized and put constraints on how those strikes could be conducted in certain circumstances. Does that answer your question? Yeah.